How do we know someone intends to say or do something hateful before they've actually done it? The only way to do it is to somehow interrogate their very thought process. And so it's not a huge stretch to say that what the Online Harms Act contemplates is a kind of thought crime. And this raises worrying concerns about restrictions on freedom of thought.
Hello, my name is Peter Copeland, Deputy Director of the Domestic Policy Program here at the Macdonald-Laurier Institute. Welcome to Inside Policy Talks, our in-house podcast. With us today, we have Chris Kinsinger to discuss freedom of expression and peaceful assembly here in Canada. Chris is a lawyer with SV Law's civil litigation and municipal law practice groups. Between 2021 and 2024, Chris served full-time as the National Director of the Runnymede Society, major Canadian association of lawyers and law students. His writing on legal issues regularly appears in the Supreme Court Law Review, the National Post, and the Hub. In 2021, Chris was selected to join the inaugural cohort of the Next Gen Fellowship with Cardis think tank, where we first met. And he served 2 terms between 2017 and 2023 on the board of directors of the Christian Legal Fellowship, Canada's National Association of Christian Lawyers and Law Students. He's past chair of the Canadian Bar Association's Constitutional and Human Rights section and an adjunct lecturer with Redeemer University in Hamilton. Chris, thanks for being with us.
Thanks for having me on, Peter. This is a nice little Next Gen reunion.
Yeah, very good. So, as mentioned, we're here today to discuss freedom of speech and freedom of assembly, 2 of the most cherished and fundamental freedoms in the Western world and in Canada. They affirm the dignity of the human person endowed with free will and the capacity to choose, which is really the precondition, we think about it, of any truly morally praiseworthy action, any good action, because it allows people to own their choices, engage with ethical values, and develop virtues that give life meaning and moral worth. So without this protection of a sphere of freedom, the rights of minorities and majorities alike are threatened, or can be, by the whims of power, and it is crucial that it is protected. And there's no doubt, I think, that free speech can be challenging, perhaps even cut against some of our tendencies to tribalism, groupthink, and insulation against that which we can find distressing, questioning. But I would say there's no question that it is good for us as well. And personally, for a society, to hear an array of opinions which advance knowledge, expose injustice, foster self-expression, discovery, and mutual understanding, tolerance, and resilience. And I think it's fair to say it's become an increasingly debated topic in recent years, with some calling for more restrictions on speech and assembly and others less. So today we'll dive into the law around free speech and free assembly, assess some of these trends, and discuss policy proposals to ensure these foundational principles are properly framed and protected. So let's dive right in, Chris. Yeah. When we think about these 2 concepts, free speech, freedom of assembly, what pieces of legislation and sections of the Charter apply? And furthermore, under what circumstances can these rights be limited? And what tests apply to do so?
Yeah, it's an excellent question, Peter, and thanks for having me on to discuss this. This is obviously a great source of interest for me, both academically and in terms of my legal practice. And I think a little bit later on, we're going to discuss some of the cases that I'm currently working on that involve freedom of expression and freedom of peaceful assembly claims. And I'm going to get to your question about, what parts of the Charter, that being the Canadian Charter of Rights and Freedoms, which is, of course, part of the Constitution of Canada. But I think before we dive into that, it's important to take a step back and to think about the historical context here. Because freedom of expression, freedom of peaceful assembly did not just arise with the advent of the charter. It's not as if prior to 1982 there was no freedom of expression and freedom of peaceful assembly in Canada. As many of your viewers and listeners will know, there was, of course, the Canadian Bill of Rights, which was enacted in 1960, which also included similar protections. Now, the Bill of Rights was not entrenched in the Constitution. It was a piece of what we call ordinary legislation, and so it was subject to repeal by Parliament at any time. And not unlike the Charter, there were provisions in the Bill of Rights that allowed for derogation from these freedoms. But when we think about the trajectory of these things in Canada, the bill was very important in setting this standard, even just politically, that things such as freedom of speech, freedom of expression, freedom of peaceful assembly mattered, and that there was an expectation that Parliament, in that case, would honor that. But really, these guarantees arise from the constitutional tradition that Canada inherited from the United Kingdom. The preamble to the Constitution Act 1867, originally known as the British North America Act, said that Canada will have a constitution similar in principle to that of the United Kingdom. And there are debates to be had about to what extent free expression might have been embedded within that constitutional framework, but certainly within that political framework and that broader societal framework, things such as free expression, free speech, and were in fact very important, and that there were expectations, particularly when it came to administrative actors, about their ability to impede on these fundamental freedoms without having authorization to do so. But bringing it back to the Charter, which is where your question started, this is the primary instrument by which claims to free expression, freedom of peaceful assembly are asserted today in Canada. And it's very important that we look, Peter, at the wording of how those freedoms are guaranteed. So Section 2 of the Charter guarantees a number of fundamental freedoms. And that word fundamental is really crucial, as is the ordering. Section 2 of the Charter is the first section of the Charter to enumerate specific guarantees. And so it's telling that the framers chose to enumerate these guarantees first and to give them this designation of fundamental, leading then Justice Dixon in the Supreme Court's landmark ruling in the Queen and Big M Drugmark to describe these freedoms as the sine qua non of the political tradition underlying the Charter. In other words, you don't get to have the type of free and democratic society that Canada has. You don't get to have democratic parliamentary governance without some guarantee of these freedoms. There is a sense in which there's a point at which, rather, they become indispensable. It doesn't mean that they're absolute. It doesn't mean that limits can't be placed on them. But to dispense with them in their entirety would be to ultimately change Canada into something that it is not. It would be to deny the very democratic nature of our constitutional settlement.
Very good. So thank you for that additional historical framing. Maybe moving on to the limits that you just referred to. Obviously, in law, there are many competing interests in play. So how are they limited, or how did they stack up against other considerations? And then what sort of tests are applied to adjudicate between competing claims?
So, of course, Peter, we have to be able to place limits on things like free expression and freedom of peaceful assembly. Part of the reason for that is in certain cases, you may have not competing claims to these things per se, but specifically in the context of peaceful assembly, when you have protests and counter protests, there's a need here to determine where the one guarantee begins and the other ends. But when we think about free expression, it's always been the case that states have placed limits on what can be expressed, whether that be through the context of criminal law and criminal prohibitions, or whether that be in a more private law context, for example, in the context of defamation law, that naturally entails restrictions on free expression, to say that you cannot defame your neighbor in law. You can't go out and say things that would reasonably lower their reputation in the eyes of a reasonable person without justification for doing so. But then even more fundamentally, in the criminal law, we have all sorts of restrictions that can arise on free expression, not just restrictions on hateful expression, which is a more recent innovation, but when we think about things like sedition, for example, and other sorts of breaches of the peace, there has long been a basis in the criminal law to restrict expression that results in these public harms. And so, again, I mentioned at the outset that none of these conversations are new. We can take this back hundreds of years into the constitutional tradition that Canada inherited from the United Kingdom. And one such comment was made by the 18th century English jurist William Blackstone. And what Blackstone wrote was, quote, that every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedom of the press. But if he publishes what is improper, mischievous, or illegal, he must take the consequences of his own temerity. And essentially what Blackstone is driving at there, Peter, is that when we are restricting expression, what we really ought to be doing is restricting the adverse consequences or the harmful effects of expression. We aren't licensing expression in and of itself. This isn't about saying what content is or is not acceptable. It's asking what harms arise from content after it has taken place. And it's at that point that we impose these restrictions on expression. And we may well have to see either private liability in the context of defamation law, or potentially criminal liability in the context of public law.
Okay, very good. So I want to dive into the actual wording chosen and how that's crafted and the test a little further. You know, in crafting legislation, there are trade-offs in play, like in any other aspect of life. And with greater specificity comes greater precision. You could even argue, you know, as the law becomes better known over time, a kind of public awareness of the meaning, predictability of legal decisions, and so on. But as we know, reality is often more complex than the concepts we use to capture it. And so sometimes an overly narrow choice of language in legislation can make it unsuited to the complexity, which we then can require further legislative amendments or the courts to fill in the gaps, the development of common law precedent. All that said, in looking at some of the terms and concepts in play here, and we didn't get into this yet, but perhaps you could elaborate on it. The Oakes test, which sets out the test for adjudicating rights in this context. They use terms there such as reasonable and demonstrably justified in a free and democratic society to outline the criteria upon which that determination is made. And I can't help but thinking in reading that and, you know, understanding some of the cases in question here, that the terms might be too unconstrained in the fixation of their meaning. So I just want to get your thoughts on this. What are your thoughts on the language and tests developed in Oakes?
Yeah, absolutely. And it's an important question, and it's one that legal scholars have grappled with since the advent of the Charter. They continue to grapple with it.
We won't solve it here today.
No, we won't. There have literally been entire books and entire volumes written on Section 1 and these ideas of justification. Just to back up quickly, Peter, when we think about the threshold tests for getting through the door for a claim for freedom of expression or freedom of peaceful assembly, for freedom of expression, the test is very low. Essentially, any activity that has expressive content and that is nonviolent and that is not presumptively not protected constitutionally. And again, we won't get into like what that means, but the point here being that the jurisprudential test for establishing just that freedom of expression has been engaged is very, very low. For freedom of peaceful assembly, and we'll talk about this more, there really is no accepted jurisprudential test for establishing a freedom of peaceful assembly claim because we have such little case law, incidentally and somewhat oddly, on freedom of peaceful assembly. So we have no Supreme Court jurisprudence governing how those claims are resolved. But when we get to Section 1, you mentioned the words demonstrably justified and free and democratic society. And just to be clear, Peter, those words come from the Charter itself. They don't come from the Oakes test. So what Section 1 of the Charter says is that the Charter guarantees the rights and freedoms set out in it, subject only to such reasonable limits as can be demonstrably justified in a free and democratic society. And what my colleague and what our mutual friend Brian Bird has argued is that we've tended to misunderstand what Section 1 is doing. And Section 1 is often conceived of as a limits clause. That's primarily why it exists, is to set out a standard by which rights and freedoms can be limited. Well, what Brian says is that's actually not the case. That's not what Section 1 actually says. Section 1 not only affirms the guarantee of rights and freedoms, it sets out the standard by which they can be limited. But it doesn't say that all rights and freedoms are non-absolute. It simply says that if they are going to be limited, that standard has to meet this threshold of demonstrable justification in a free and democratic society. So demonstrable, meaning that it can't just be speculative, right? The onus is on the state to marshal the evidence to show why this restriction is necessary. And then within this broader context of being in a free and democratic society. And so backing this up to kind of what I said, Peter, at the outset, when we think about fundamental freedoms, and we recognize that these freedoms are fundamental, I think this raises interesting questions when we apply the limitations aspect of Section 1 to the fundamental freedoms, right? How do you limit a freedom in a free and democratic society? And I think part of the answer is we have to recognize, as I said, that these fundamental freedoms will need to be limited. That's not controversial. Taking an absolutist approach doesn't really get us anywhere. But we do have to have very rigorous standards and thresholds that apply when we are going to place limits on these freedoms. And I think that's the concern that has arisen with the case law, particularly with the case law surrounding Section 2B and its guarantee of free expression in Section 1. So we don't need to go into great detail what the Oakes test does, but essentially it lays out a number of standards for limits. So limits need to be prescribed by law. They have to pursue a pressing and substantial objective. They have to be rationally connected to that objective. They have to be minimally impairing of the right or freedom in question in their pursuit of that legislative objective. And then we get to the end, and this is the most controversial part of Oakes. It has to achieve overall proportionality, and the language, and it's very, very flowery legal language, is that the salutary benefits of the law have to be proportionally balanced against its deleterious effects. And this has been the most controversial part about Oakes. The late, great Peter Hogg, a titan of Canadian constitutional scholarship, himself felt that the last stage of Oakes was redundant, unnecessary. Former Chief Justice Beverly McLaughlin disagreed with Professor Hogg on that point in several of her rulings. But I do think that when you look into the case law, you do see these issues that start to arise when the focus is so much on this idea of proportionality to determine what is a salutary benefit, what is a deleterious effect. It can become very normative. It can become very policy driven and not governed by rigorous legal standards or doctrine. And we can get into this more, but that has created very specific problems within the context of Section 2B and how the courts have applied Section 1 to the guarantee of free expression.
Yeah, it's almost like that last piece is quite open-ended and without any firmer doctrine or standards specified, you end up with apples and oranges and, kind of free play of concepts and perhaps policy or even political evaluations coming into play.
And to be clear, Peter, I mean, the law is what it is. The test is what it is. So I'm a practicing lawyer. Like I said, I work on these cases. I argue the Oakes test because that is what the law is. But I would like to see a more robust development of that last stage of the test in particular. One potential change that could be made there is recognizing that the last stage of Oakes is the last opportunity for rights claimants to have their rights vindicated. So how do we weigh that? And is it weighed too heavily in the side of the state? Should we weigh it more heavily in the side of the claimant to recognize that this is their final opportunity to have their rights vindicated? And so we should not undertake a proportionality analysis speculatively or as a policy-driven analysis.
Very good. So we don't need to get into too much detail here, Chris, but if you wouldn't mind just giving us some of the highlights, the most influential cases and decisions in this domain that have further established the precedent.
Yeah, so I'll in a few moments I'll highlight two recent cases because there's a long-standing history of freedom of expression case law. We would be here all day if we went through all of it.
Yeah.
It's not something that has been brought before the court too often of late. We only have a few cases within the past decade or so that have dealt with free expression. But, as I was alluding on the issue of how Section 1 cases are resolved within the context of 2B, part of the issue, as I said, is that the threshold to establish a 2B claim is very low. And again, as a lawyer, as a practicing lawyer, I take advantage of whatever the threshold is. But there are ways in which I think it would benefit the case law to impose a higher threshold to establish a 2B claim, to let fewer claims in through the door if there is a corresponding increase in the state's threshold of justification under Section 1. Because right now what we've seen is what's called the contextual approach, where essentially, as I say, basically all nonviolent expressive conduct is for the most part deemed to be constitutionally protected. And then under Section 1, there's this added element that has arisen in the section, in the free expression jurisprudence, to ask whether the expression in question is high value or low value. And this really plays into the concerns about the subjectiveness of the Oakes test in particular, that it becomes policy driven. And it puts the focus with limits on free expression, not on the limits themselves, and not on with the harms, the consequences of the expression that they're seeking to prescribe, but with the actual content of the expression in question. And that's a worrying trend, Peter, because when we go down that path, it opens the door to essentially creating a licensing regime for what is or is not acceptable expression or conduct, which is very high value, low value, which is contrary in many ways to the very idea of having a free expression guarantee. It's meant to preserve a political, legal status quo, a civil polity in which there is freedom of discussion, right? This is the constitutional soil in which democracies flourish. We can't have democratic governance if there isn't some threshold guarantee of free expression. And there isn't a way, bring this back to freedom of peaceful assembly, that individuals can come together and they can gather, demonstrate, protest as they need to further their political democratic objectives. But two recent cases, Peter, from the Supreme Court that I'll just highlight. The first, back in 2013, was the Saskatchewan Human Rights Commission and Watcott. This was a very famous case. I won't go too much into the facts. Mr. Watcott was an anti-LGBTQ activist. He would put flyers and mailers in various people's mailboxes. And this wound up with him getting a complaint that had been filed against him pursuant to the Saskatchewan Human Rights Code. And there were fines that were imposed there. And what the court held in that case is that the Saskatchewan Human Rights Code went too far. It didn't simply go after, as I say, this merely hateful expression, but it also prescribed expression that ridiculed, belittled, or otherwise affronted the dignity of a person or classes of person. And what the Supreme Court held in that case is that that is not a sufficient basis on which to limit free expression. So we get this idea that emanates from this case that merely offensive or repugnant speech is constitutionally protected. Does not rise to the level that we can justify limits on that type of expression in a free and democratic society. Fast forward to a few years ago from the Supreme Court's 2021 ruling in Ward in Quebec. Again, many of your viewers and listeners are probably aware of this case. Mr. Ward was a stand-up comedian. He had engaged in a comedy act in which he quite offensively, even horrifically, had mocked this teenage activist who had a disability. And so he was a disability rights activist. And so similarly, he had various complaints, fines brought against him pursuant to the Quebec Human Rights Code. And in that case as well, Peter, what the Supreme Court held is that even though this expression was offensive, that's not necessarily sufficient basis on which to limit free expression. What the court said in that case very clearly is that there is no such thing in a free and democratic society as a legal right to not be offended. That can't be the threshold. We have to point to some more fundamental, broader societal harm that is arising than simply offensiveness or even, expression of that nature.
Very good. Well, I think that gives us hope then, those two cases. Let's shift to one.
We'll see. Yeah.
Yeah, let's shift to one even more recent, in which you're involved in a challenge to Waterloo Region's unconstitutional harassment bylaw. What issues are in play here?
Yeah, so here I am representing the Canadian Constitution Foundation. Again, many of your viewers and listeners probably are aware of the CCF. They are a national civil rights, civil liberties advocacy group in Canada. They have done a lot of really fantastic work, and I'm really excited to be representing them in this case. Their concern here, Peter, is with a amendment to the Region of Waterloo's existing Code of Use bylaw. And to be clear, my client does not take issue with the Code of Use bylaw in and of itself. The Code of Use bylaw regulates conduct on regional premises, so it prohibits things like nuisance, like loitering, vandalism. It's what prevents people from lighting up while they're on a bus or a train or something like that. So most municipalities have these kind of bylaws in place. What the region did a little over a year ago is it enacted an amendment to the Code of Use bylaw to also create this so-called anti-harassment provision. So now the prohibited conduct on regional premises is going to also include things, well, the standard is that it is now also prescribing objectionable or unwelcome conduct that could reasonably cause offense or humiliation. And I don't think I need to, connect the dots too much here, Peter, to show how on the basis of what we just went over, on the basis of cases like Watcott and Ward, that does not meet the standard for what is a permissible restriction on free expression. So there's a very clear charter issue here. The CCF wrote to the region when this amendment to the Code of Use bylaw was enacted to express its concern, to urge that the region repeal the amendment and engage a peer review before it proceeded with any similar amendments. That unfortunately did not happen. And so this has necessitated that we bring an application in the Ontario Superior Court to quash the bylaw. But just really quickly, Peter, even more fundamentally, putting aside the charter issue here, even irrespective of those concerns that the CCF has, and I think they are sufficient to render the amendments to the Code of Use bylaw unconstitutional, there's a question about whether municipalities are even empowered to enact these kind of provisions in the first place. Because what the region is really looking to do here is to create its own watered down carbon copy of the existing prohibitions on hateful expression that are found in the criminal code. This is what we would say in legal terms is, in pith and substance, in its very essence, is a criminal prohibition. The problem is that Parliament has the exclusive legislative authority to enact criminal prohibitions. And provincial legislatures and the municipalities that they create do not, because we have to remember here, municipalities do not exist independently. They are creatures of the province. They only exist because the province creates them and then delegates some of their powers to them. And so what we are saying in this case is that not only has no such delegation taken place to enact this kind of prohibition, but such a delegation could not have taken place in any event because the province does not have authority to enact its own versions of hate speech prohibitions of the nature that are enacted already in the criminal code. The municipalities they create cannot do the same thing as well. So there's a more fundamental issue here that needs to be addressed, Peter, about how municipalities are, the type of bylaws that they enact. And look, to be clear here, this is not about, this is not to disparage the region's motives. This is not to suggest that the region want to be concerned about harassment and various forms of hate in the community, of Islamophobia or anti-Semitism or any number of these other types of hate that we've seen of late. But the region has to operate within its constitutional constraints and within the legal constraints of the powers that it has been given by the province pursuant to the Municipal Act.
Very good. And I look forward to seeing how it plays out. And I think that would be a perfect segue to a discussion of the contemporary policy landscape and state of public discourse and opinion around these matters. So I want to get your thoughts, Chris, on what you think the current issues are driving all of this interest in free speech, its curtailment and its protection. I think, it's fair to say, as mentioned at the outset, many people advocating for far fewer restrictions on speech. It's been somewhat of a rallying cry for different aspects of society. People citing censoriousness, ideological bias, scapegoating and social ostracization associated with things like cancel culture, for example. And then the other, you see increased demands for restrictions on speech due to the perceived harms associated with aggressive, misleading, or even the rise and proliferation of misinformation, however that's defined, or simply the stating of opinions that one disagrees with, and then the impacts of speech on certain population groups. We've seen free speech codes created at universities, a new university even sprung up, and then I think on the other side you see things like the online harm bills that have arisen both in the UK and proposed here in Canada that have faced criticism due to overreach. So in your view, in light of all that we've said, when does free speech need to be restricted? Are our laws already adequate in this regard, or do they need refinement?
Yeah, I mean, that's a big question, right? Is the law adequate? And I think this is the task of legislators to be looking at problems as they arise and to ask, is the law currently sufficient to respond to these problems, or do we need to take greater steps to respond to even potentially new problems as they arise? And we can see, Peter, these concerns that arise can arise very suddenly. Much of this conversation has been driven and has changed since the events of October 7th, 2023, of course. And the new questions have arisen not only about how do we respond to various types of protests, how do we respond to occupations. That's not even a new one. That can go back to even the so-called Freedom Convoy in Ottawa a couple of years ago. You can bring this back to the Occupy movement, the G20 protests, and all of these things. So it's hard to say whether the state of the law is currently adequate. I mean, if we want to use a practical example, we want to bring this back to, not to keep beating my own drum, but to the challenge that I'm bringing on behalf of the CCF against Waterloo region. I would say in that case, I think there is adequate protection already in the law. You already have a code of use bylaw that prohibits things like nuisance. So that prevents people from coming onto, for example, a bus and harassing a woman because she's wearing a hijab. You don't need to create a carbon copy of the criminal code prohibitions on hateful expression. And to the extent that that conduct crosses the line into hateful expression, then I would say take advantage of those existing prohibitions against
Yeah.
those who would direct hate in that way against members of vulnerable or protected groups. But when we think more broadly, certainly on the one hand, we see very valid concerns about things like cancel culture. We see concerns about related ideas like academic freedom and wanting to ensure that in university spaces, in particular, students and faculty are able to engage in free discussion and a free and frank exchange of views. This is an issue very near and dear to my heart. As the former national director of the Runnymede Society, we exist in large part to go into law schools and to ensure that there are conversations that are happening that are not probably otherwise going to take place, to see that students are exposed to different points of view, different issues, that they are seeing these debates play out in real time, so that even if they don't change their mind on an issue, they're at least better informed, or they understand their existing position better. So you've got the concerns on the one side there. And then on the other side, though, you have these new policies popping up, like the Online Harms Act. And, the proposed Online Harms Act here in Canada is very difficult to respond to because it is just so big. One colleague referred to it as the Online Harms and Other Stuff Act. It is just such a massive dog's breakfast of legislation that you really have to break it down into its component parts. And there are parts in there, Peter, that I'm not concerned about, and I'm actually quite sympathetic toward the provisions that are seeking to help protect children on the internet, for example. And I note that the Conservative Party and Michelle Rempel-Gardner have proposed their own version, essentially, of the Online Harms Act that they say takes away the problematic aspects of the version that is being backed by the Liberal government. I haven't had an opportunity to review the Conservative version in detail, so I can't speak to my own views on that. But I will say for the government's version, the big concern that I have is in the amendments to the criminal code. And I've written about this a little bit for the Hub, and I'm working on some other projects on this issue. But the real concern here is that essentially it creates a whole new class of hate-motivated offenses. So it creates a new definition of hatred. And essentially what the amendment to the criminal code would do is make it a criminal offense liable for up to life imprisonment for any federal offense committed with a motivation of hatred. So not just any offense under the criminal code, any offense under any other federal act. So I believe it was Michael Geist who gave the example that someone can commit an offense under the National Parks Act. And if that was motivated by hatred, they are now liable for up to life imprisonment. So that's a very draconian amendment, in my view. But perhaps even more worryingly are these new provisions essentially for the imposition of peace bonds against individuals who are feared, whereas it's feared that they are likely to commit one of these hate-motivated offenses. And what concerns me about this, Peter, are two things. One is that it gets us away from focusing on the adverse effects of expression that we talked about. It requires an interrogation of the content of expression before it has taken place, and then to essentially set up a censoring licensing regime of what is or is not acceptable conduct. And that decision is going to come down to individual judges who are, no disrespect to them, likely not going to necessarily be equipped to undertake that kind of analysis. But then it also is going to require those judges to do an interrogation into what has been deemed a person's inner forum, right? How do we know someone intends to say or do something hateful before they've actually done it? The only way to do it is to somehow interrogate their very thought process. And so it's not a huge stretch to say that what the Online Harms Act contemplates is a kind of thought crime. And this raises worrying concerns about restrictions on freedom of thought. So this is another of the fundamental freedoms guaranteed by Section 2, right? Section 2B in particular doesn't just guarantee freedom of expression, it guarantees freedom of thought, belief, expression, and opinion, including freedom of the press and other forms of communication. And so I mentioned earlier on, we talked about our colleague Brian Bird, who has said that Section 1 is not just about limits, it's about it's about guaranteeing rights, and it's about the standard against which limits are to be assessed. And so what he has posited is that restrictions on freedom of thought may actually never be justified, because how could you ever justify a restriction on freedom of thought in a free and democratic society? There's a case to be made there that there is no demonstrable justification available in any event. So these are very real concerns with the Online Harms Act. This is being debated. It's currently going before the Heritage Committee for further study. And so we will see what comes of that. Of course, we all know it is likely that we are going to have an election here in Canada in the next year or so. And so depending on the outcome of that election, it is possible that the Online Harms Act either won't pass in time for that election, or if it is, might be repealed. So we'll have to wait and see.
Yeah, well, much to think about there, Chris. You've given us. I can't help but think just on the individual psychological level, and I think you see this in group behavior as well, that the more you try to restrict such, fundamentally important an aspect of, a person's life, which is freedom of expression and assembly, the more likely you are to have an adverse reaction. And, even you can see how it's a bit of a vicious cycle, right? And why it's so important to have very strong emphasis on how fundamental these freedoms are. And what came through in the examples you mentioned, just the importance of specificity, severity, having very clear standards and objective ways of determining when some breach is occurring. And a lot of the examples you referred to, this is just not the case. So final question for you, Chris. Which legislative actions, maybe broad approaches to take, I guess you could say, do you find most promising? Or do you think non-legislative routes are more promising to address some of these issues about the perceived and real harms associated with speech and assembly, while affirming their fundamental importance and protection?
Yeah, I'm not opposed to legislative intervention. I think the challenge with the fundamental freedoms is that they really do exist, as I say, as a sort of status quo, right? It's about preserving this sort of civil polity within which a free and democratic society can flourish. And so in many cases, it doesn't necessarily require a laissez-faire approach, but there is a certain degree of a hands-off approach that I think can benefit our approach to fundamental freedoms. That being said, Peter, there are real challenges that we can face in terms of attempts by private individuals to restrict the exercise of fundamental freedoms. And I think in those cases, there is an important, albeit limited, role for the state to protect the exercise of fundamental freedom. So this isn't necessarily about creating a so-called positive right to free expression or freedom of peaceful assembly, but I think it does recognize that in order for those freedoms to be exercised, there may be some state action that is required to at least prevent others from coming in and in bad faith seeking to undermine the exercise of fundamental freedoms. So one really good example, our criminal code includes a provision that makes it a criminal act to disrupt a religious service. So you can't walk into a church or a mosque or synagogue with the intent of disrupting what's going on within. Now, let's be clear here. That's a restriction on freedom of expression. It restricts someone's ability to go in and express their opposition to whatever, to organized religion, to whatever religious gathering is taking place. But what that law recognizes is that such a protection is arguably necessary in order to preserve the freedom of peaceful assembly of those who are gathering for a religious purpose, and to similarly protect their freedom of expression. And so there was one such case dealing with that law, which made the comment that freedom of peaceful assembly could be meaningless without these kind of protections. Incidentally, the federal government about 7 or 8 years ago was seriously considering getting rid of that provision. And thanks to the work of various advocacy groups, many of them religious advocacy groups, they backed off, recognizing, at least I hope, recognizing the value of that kind of provision. But I think we need to think about that a little bit, Peter. And I think we need to think about that in the context of all the different types of protests that we've seen emerge over the past several years. We had, of course, the Freedom Convoy in Ottawa. We've had recent anti-Israeli, pro-Palestinian protests take place on university campuses. And there are important questions to grapple with here about where does freedom of peaceful assembly and freedom of expression in those contexts end? Does it give me a right, for example, to prevent people from accessing their private property, right? That was a case with the Freedom Convoy in Ottawa. In some cases, there were individuals who couldn't get into their condos in downtown Ottawa because they were being blocked by protesters. What does this mean on university campuses if someone can't get to class or can't make use of space? But how do we balance that against the, recognizing that in the case of university protests, that protests are a part of university life, and they've pretty much always been a part of university life. That's just part and parcel of the university experience. So I think what governments, they need to tread very carefully, and they need to do so with an aim to, and this is getting now kind of to the meat of your question, trying to give some kind of practical policy takeaway, is to ensure that the freedom itself, right, and that status quo is being preserved as much as possible. And that might require creating some semblance of order so that you don't have what's called, the heckler's veto, preventing legitimate exercises of expression or peaceful assembly, while also making sure that the restrictions imposed in those cases are not too onerous as well, and that there is space that is left open, for counter expression, just in a way that doesn't deprive the original expression of its force.
Very good. Good note to end on. Thank you so much, Chris, for joining us today. I'm Peter Copeland, Deputy Director of Domestic Policy. Thanks for joining us for Inside Policy Talks.
Anytime, Peter. Thanks for having me on.